Clown egg hunt. Clown egg hunt.
Welcome to Wild True, the podcast of your wildest memes.
We're here to dissect the entire internet, something normal to want and possible to achieve. I'm science fiction author, not your attorney, and intellectual property experiencer, Isabel J. Kim, Esquire.
And I'm Amanda Silberling, an internet culture reporter and intellectual property haver. Anyone could be famous on the internet, so why not us?
Yeah, our intro is definitely better than it used to be and not worse. Anyway, today in the podcast recording studio, aka the internet, we don't have a studio. Please welcome my sugar daddy Sam, who is actually an IP attorney. Specifically, you mostly do trademark work, right?
Yes, and I am very excited to finally be invited onto this podcast that I've regularly been annoying you about in the group chat for years.
Yes, because, this is actually how you get onto the podcast, is that you just have to annoy us in a group chat enough, and eventually you'll be invited on. This is how all of our guests happen.
I feel like we should do an episode where it's just everybody that we know in real life who wants to be on the podcast talking about a very specific thing, like how my friend Andrea really wants to come on and talk about My Chemical Romance, and I'm like, well, what about My Chemical Romance? And she's like, Gerard Way, and I'm like,
No, let her cook. She's right. She's right about this.
Literally every time.
Behind every podcast host is a friend who wants to come onto the podcast to talk about MCR.
Although, is this not what the Island episodes were?
Let me cook.
Okay. So sometimes we make jokes about me being the IP person on the podcast or being a lawyer or some shit like that. That's not what I do, which is why Sam is here, because we're talking about IP and the internet today. And I thought it would be fun for once in our lives to have somebody who knows what they're talking about. I just slandered both of us. So sorry, Amanda.
We specifically were trying to work on not talking shit about ourselves on our podcast.
Let me cook.
Okay.
Although, to be fair, Isabel, every time this podcast says something about IP law, I will text you in the group chat and be like, no, you got it mostly right, but can I talk about it more? So that is why I'm very excited to be here.
Well,
Yes.
Don't worry. One day when we do our leveraged finance episode of Wow If True, which is definitely what our listeners are here for, it's over for you.
Listen, we're like Matt Levine, but bad. Is that anything?
Matt Levine is funny. I like him.
I mean, I've mentioned this before on the pod, but one of my friends has said, yeah, you talk like Matt Levine speaks, so I read all of his posts in your voice. And I was like, I don't know how to react to that.
For those who don't have to think about finance for any part of their work, Matt Levine is a Bloomberg reporter who has a finance column, but it's pretty good. As someone that thinks finance is actually fake, it's pretty good.
I would say that that's actually the only finance column worth reading, and also if you read it, then you can pretend to be someone who knows a lot about finance, because every single lawyer at my law firm reads it. Okay, let's actually talk about what we were here to talk about. So we're back on the AI train, parentheses, derogatory. But back in May, OpenAI, which we have talked about on the pod before, but the AI company, OpenAI, announced as part of a larger update to ChatGPT 4.0. I think it's an O and not a 0, right?
I think it's pronounced 4.0, but it's it is an O. It's very confusing, the branding of it all.
Right. So basically they were like, hey guys, we've got voice now. We can do voices. So they announced this through a video because when you have voices, you want to announce that through video. That's ooh, look at our voices. Look how they sound.
And that's why podcasting is pivoting to video.
And this is how podcasting is pivoting to video, yeah. And so they had some ads that had a very bubbly girl voice. Incidentally, we should probably talk about how all AI is a girl voice.
Yes.
Why is this the timeline we're on?
Yeah. But pouring out for Bixby. Bixby from Samsung is officially no longer with the release of the new Samsung phones. This is something I only know because I had to make a video about it for work. I did not know what Bixby was before, but it was a Samsung voice assistant.
I've learned so much. This was a total net neutral information game because it's this thing existed.
And now it doesn't.
There is an AI with a male voice, actually. It's the AI from 2001: A Space Odyssey, and he's the malevolent AI, but all of the helper AIs have female voices, so there's some feminism for you.
Yes, because feminism is helping people.
So there's some real gender going on.
Feminism is me making myself useful to men as an AI that can answer all their questions, ?
I think feminism is when I'm unhelpful to men.
You know, it's like Janet in The Good Place. What if Janet in The Good Place was a man? Gender. This is gender studies.
Is that not what Derek from The Good Place was?
Derek from The Good Place is, like, bad, though. He's, like, very incompetent.
Yeah, it's weaponized incompetence. He's weaponized incompetence AI.
God. Well, speaking of weaponized incompetence, Sam Altman, the CEO of ChatGPT, was like, haha, what if we made a voice that sounds like Scarlett Johansson in the movie Her? Haha. And then he did that, and then Scarlett Johansson was like, bet.
Was like, can you not? Yeah, okay, so the movie Her. Her is a movie from 2013 by Spike Jonze, basically about a guy who falls in love with an AI. This was too accurate to what life would be like in 2024, but that is fine. My hot take is I thought the film was good, but basically Scarlett Johansson plays the AI, so she's never physically present. It's just her voice that is playing the character Samantha, who the main character falls in love with. And Sam Altman was like, hey, I like this one. I'm going to make a tweet that just says Her. And also, like, it's kind of, like, well known that he was into this film, which is, like, that's not a crazy thing to be. It's a good film. I don't know if either of you guys saw it.
I think I saw it when it came out because Arcade Fire did the music, and I was like, oh boy, I love Arcade Fire. It's 2013, and I'm in high school. Also, I think that this is a point in the column of our theory that we talked about on our patron-only book club plug, where Isabel, for some reason, read the Elon Musk book, and we talked about how all of these, like, wealthy men with a lot of power are just trying to recreate the science fiction stuff that they liked when they were younger, without realizing that science fiction often is, like, showing why a certain change in the world would actually lead to perhaps something worse than our current society.
Wait, I have a question for both of you now.
Yes.
If you were a wealthy man, step one, be wealthy man, what would you try to recreate from when you were 14?
I mean, my dream was always to, like, have my own Pokemon.
Me too!
So I feel like I would make a startup that, like, messes with the genetics of, like, dogs to make them behave more like Pokemon. And
Yo, this is, like, moderately evil. That's, like, a moderately evil startup.
Yeah, but in this world, I would be evil because I'd be, like, a random billionaire guy.
Okay, Sam, what are you doing?
Honestly, there was nothing that I enjoyed about being 14.
So valid.
So you would excise the idea of being 14 from our culture. This is what I'm hearing.
I would actually just give every teenager the chance to, like, go on their own little hero journey instead of having to deal with, like, whatever society is.
You're inventing the Bildungsroman.
Either that or the Pokemon Quest.
Pokemon Quest!
Yes.
Yeah, it all links
Yes.
back to Pokemon.
Yeah. Our startups can collaborate. I'll buy you out.
Okay, well, now I'm glad that neither of you are wealthy billionaire men. And now I feel way better about Sky, which is the name of the ChatGPT 4.0 Scarlett Johansson clone situation.
At least neither of our startups are AI.
I don't know, you could integrate AI into this. You could make it like the AI decides what route like this child goes on when they're 14. This AI is fucking with the dog's genetics. Is this anything? This is nothing. Okay, I'm going back to my main statement, which is that basically a lot of people were like, hey, this girl AI voice sounds a lot like Scarlett Johansson. Is that on purpose? Is this like the movie Her? And then people were like, haha, maybe it is, maybe it isn't. And then basically what happens is that Scarlett releases a statement, which is like clearly written by her attorney or written by like someone on her team, where it's like, last September, I received an offer from Sam Altman who wanted to hire me to voice the current ChatGPT 4.0 system. He told me that he felt that by my voice in the system, I could bridge the gap between tech companies and creatives and help consumers to feel comfortable with a seismic shift concerning humans and AI. He said he felt that my voice would be comforting to people. After much consideration for personal reasons, I declined the offer. 9 months later, my friends, family, and the general public all noted how much the new assistant named Sky sounded like me. And basically the rest of it goes on to say,
when I heard the released demo, I was shocked, angered, and in disbelief that Mr. Altman would pursue a voice that sounded so eerily similar to mine that my closest friends and news outlets could not tell the difference. Tag yourself, I'm my closest friends and news outlets. It's a good statement. I don't know why. I just think that's really funny.
It's a really, like, powerful statement, and honestly, this is like, oh yeah, Scarlett Johansson has, like, lawyer money. This is great.
You know what this reads like to me, actually, is basically, so as an intellectual property attorney, this happens a lot, where a client is like, hey, we want to do this thing, and then you say no. And then they come back to you, like, 6 months later, and they're like, hey, we did the thing anyway. What's the consequences of us doing the thing? And so you kind of have to just give them the best advice that you can on the basis that they did the thing that you told them not to do. And, like, this happens a lot with, like, startup companies and, like, tech guys, where they're so opposite of lawyers, lawyers are incredibly risk averse, except is.
This is Wharton's influence.
Yes, yeah, it is. But, like, lawyers are so risk averse, and, like, startup guys are, like, basically the opposite end of that, where they just do whatever the fuck they want, and then they hire us to, like, deal with the consequences later. So that's what that reads like to me, is, like, someone who works for, this is hypothetical, right? This is not at all definitely what happened. This is my, like, hypothetical, probably maybe what happened, which is someone who works for Altman was like, oh, we should probably clear this with...
No, but see, this isn't Altman's statement. This is Scarlett Johansson's team.
Yeah.
Released the statement.
No,
yeah.
So, like, someone who works for Altman was like, hey, we should probably see if we can get ScarJo on board. She said no. Mm-hmm. And Altman either didn't know or didn't care and was like, fuck it, we'll do it anyway. And then his lawyers freaked out and were like, oh my god, you're mimicking her voice without, like, asking her, without her giving permission. And she actually explicitly told you no. Let's see if we can fix this. And now they're just, like, trying to deal with the fire as best they can. That's what this reads like to me as someone who is not inside that situation.
Yeah, I mean, I think your assessment there is correct, because it does also detail out, like, what was happening in the moment, which is that, oh, the demo gets released, or, like, right before it gets released, Sam Altman contacts ScarJo's agent and being like, hey, can you reconsider? But then the system goes out, and then ScarJo gets a lawyer, and then that lawyer sends some letters, and then OpenAI takes down the Sky voice, which sounds just like you're saying that Sam Altman was just like, hello, let me do actions. And then ScarJo was like, hello, I'm threatening litigation. I was kind of hoping, this is a kind of a horrible thing to say, but I was kind of hoping that this would reach that litigation stage, because I was kind of hoping to read the complaint.
Yeah, because it'd be fun.
It'd be fun. It'd be good content. I've reached a part of my life where I want lawsuits to happen, so I have stuff to read on my podcast.
This is why being a litigator is fun, because it literally is just like gossiping professional.
So, Sam, for me as a journalist, sometimes I find reading lawsuits fun because people get, like, really spicy in them. Is this just because the lawsuits I'm reading are the ones that are, like, startup bros going at each other, or is this a thing in litigation?
It is a thing. It depends very much on, like, basically the attorneys and also the judge, or really the judge's clerk, who is the one who's writing usually the decision. But yeah, it can get pretty spicy, and especially when you get parties that are, like, just fighting each other tooth and nail over really stupid shit. The judge just, like, wants to smack everyone down. So it's actually called a bench slap when they'll issue a ruling where it's so clear that the judge is annoyed and they're using all of their actual, like, intellectual and linguistic capacity to be like, please stop making this my problem and go away and deal with it yourselves, you absolute children. Why are you admitted to the bar?
Yeah, that happened in, I think it was a case between Elon Musk and the Center for Countering Digital Hate, when Elon sued them for their research impacting advertising, allegedly, quote unquote, insert allegedly here. And I watched the hearing, and the judge just seemed so pissed off. And then I think to the lawyer for Elon Musk, he was like, this is the most, like, asinine explanation of insert whatever law it was here I've ever heard in my years of being a judge.
Yeah, and you can tell the judge is just so annoyed at that point. There's also some of the, like, bigger IP cases have, like, some really funny bench slaps and, like, rulings. I think my favorite is, if I remember correctly, this is from that Barbie copyright case where the
Aqua versus Mattel, or Mattel versus Aqua.
So that one's actually a trademark case. I'm thinking of the copyright case where one of the lawyers threw the Barbie head at the other lawyer.
Oh, yeah, really
yeah.
good.
And I think that's the one where it's like the parties are advised to chill, or was that the Mattel one?
That's the Mattel one. Hey, do you think there's something about, like, Mattel and Barbies that just leads people to be insane? Because now that I'm thinking about it, it's like 2 for 2
Yeah, no,
on that.
those were both very insane cases. I think it's just probably that Barbie was like super popular, and so everyone was trying to rip them off in the 90s.
Yeah, this seems, maybe it's just what the 90s were like. But okay, back to original point. So I thought it was an interesting question of like whether Scarlett Johansson could actually sue. I mean, okay, anyone can sue anybody. We live in, this is America. But like whether she had an actual case against OpenAI. I have opinions on this. I want to hear what you guys think first. Or we could just talk about it like normal people.
As someone with no legal expertise, I wish it was illegal, but I'm going to say that by some weird technicality, it's probably legal, and they just took it down because ScarJo went public and people were annoyed about it.
Mm-hmm.
That's actually often what I advise my clients is like whether or not it's legal or illegal. If you cause a shitstorm on Twitter, that'll probably get you a faster result than suing someone.
Hey, what's the professional way you say that?
I usually say it like that. My clients like that I'm pretty that I'm not particularly formal, especially when you work like with entertainment clients or like people like pro bono clients especially. I don't think they care if I usually I don't curse, but sometimes.
This is not legal advice. Start a shitstorm on Twitter.
Oh my god. Yeah, let me preview all of this. None of what we're saying on the podcast today is legal advice.
Except for things that I say because I cannot be disbarred because I'm not in the bar.
Everything Amanda says is legal advice. Everything Isabel and Sam says is not legal advice. Does this help?
I think also, Amanda, you could probably go to jail for impersonating a lawyer, but that's also not legal advice.
Aw.
No, but we directly say here that Amanda is not a lawyer.
There we go.
I'm not a lawyer, but if you want to take what I say as legal advice, I can't stop you.
But yeah, no, I mean, I think it is an interesting question, and I think to be as annoyingly lawyery as possible about this, it is an issue of first impression, which means that like there is something legal or illegal. That's why when Iz and I were talking about this, I was like, oh, we should do an it depends counter, because like the joke is that any question you ask a lawyer is they will say it depends, because it always does depend on a lot of things, because like even when you think about murdering someone, is killing someone illegal? It depends. Were you doing it in self-defense?
Damn.
Then maybe it's not. Also not legal advice.
I feel like this is the equivalent for, in Judaism, if you ask a rabbi something, they'll go, well, I don't know, what do you think?
I think it is an issue of first impression, which means that the courts have to make a smart decision, which means that it probably won't be a smart decision. I think based on the precedent, it's pretty clear that it was illegal, in my personal not legal advice opinion, because of that Midler v. Ford case is that you very kindly researched for me, in which basically the Ford Motor Company used a sound-alike for Bette Midler in an advertisement, and she sued on the basis of a right of publicity in California. Problem is that a lot of the right of publicity, well, let me back up. Right of publicity is different in every state, is a state-by-state regime as opposed to being a federal law. Most intellectual property cases are federal cases because they're based on federal legislation.
Yeah, I think honestly, like this is the only thing that wouldn't be federal law, because like patent, trademark, copyright. I guess
copyright is federal.
I guess you can have trademark and copyright stuff that's like state by state, but it's like
you can have trademark stuff that's state by state, either through common law or through the state register. But yeah, no one cares about those. There's very few. I think I've done like 2 state trademarks in my entire career, and then copyright is always going to be federal. I think that's like a very clear case. Oh, sorry, right of publicity. So basically, if you are a famous person in some states, you have a right over your likeness so that other people can't use your likeness. In other states, it is that you only have a right of publicity or an expectation to privacy, depending on the state and how they phrase it, if you are not a celebrity. So there are some states in which celebrities have no right to privacy about their image whatsoever, because that state decided if you're a celebrity, then you just are like always in the public eye.
That's so interesting, because then how do you define celebrity? Like, at what point do you become a celebrity? And that's very interesting on this podcast, where we are determined to become niche internet micro-celebrities.
It depends.
Yeah, I was going to say that, like, and two. But that's what I was going to say, is that, like, I feel like the ScarJo case is a little less interesting, because ScarJo is, like, obviously a celebrity. And if this was like a Twitch streamer or something with like a very distinctive voice, that would be very interesting because that would very much be riding the line.
Okay, imagine that you are someone who is like a niche internet micro celebrity and someone is using your likeness, but you're in the state of California and there's the rule that if you're a celebrity, then they can do it. And then you have to explain in court why you're not famous enough to be considered a celebrity.
This sounds like the plot of like a very bad movie. I could see this being like a very bad
Let's
movie.
go. This is what The Rural Juror is about.
God. Yeah. Like, I mean, California was kind of interesting because I feel like California had stronger right of publicity laws than other states just because Hollywood exists. So the amount of common law that I saw was larger than in other places, like the common law and also like the legislation.
Yeah, I agree with that. I think the right of publicity is so developed in California because of LA, basically. And because you get a lot of paparazzi shots and people getting in fights with paparazzi and stuff like that. And that's how the law is developed, by people suing about it. I think there's one other perspective on the OpenAI stuff, actually, which is, clearly they're imitating ScarJo's voice in Her, and so I think there's like a copyright question here because arguably,
right, because that's like it's not just her, like it's not just ScarJo, it's Her the movie and the actual voice in the movie which has copyright.
Yeah, exactly.
As opposed to the human.
Yeah, so there's I think we're gonna get a little more into this later, but like there's fair use about copyright and there's very specific rules about like whether something is fair use of a copyrighted work. And so like this is how all AI kind of skirts around copyright law, because the way that AI works is they take a bunch of stuff and they kind of like throw it into a blender and then they spit out the common denominator. And so they're not an AI piece of art, if you want to call it that, is not reproducing any particular artwork. They're reproducing the average of a bunch of artwork that's like publicly available, even if it is not allowed to be used to be reproduced at all. And so like if OpenAI did create the Sky voice by just basically directly copying ScarJo's voice in Her, there's not only the right of publicity, there's also the copyright that the owners of the copyright for the film, which is usually like the production company or whatever, hold over the movie. And by taking such an iconic part of the movie in particular, they could make a pretty good argument that that is not fair use either.
But then does that change in cases like there's the artist Greg Rutkowski, who did a lot of the art for various D&D publications and has a very distinctive like fantasy dragon style, and a lot of people were going into Dolly and stuff and being like, here is a crazy dragon but in the style of Greg Rutkowski, and then it spits out something that very clearly looks like his work. Is that also like, oh, but it's like an interpretation of it, or it's transformative, or does it change when it's like, make me a dragon that looks like Greg Rutkowski specifically?
The way the copyrights work is they are over particular pieces of art, not over his whole catalog. Your art style is generally not something that you can protect via copyright. There's like one example where I think it kind of comes close, which is the clown face egg depository.
God, what? The fucking... Okay, but the clown face egg depository... Okay, you know what? No, we're going to the mid-roll, and then we'll come back, and then we'll talk about the clown face egg depository. I wasn't expecting to talk about this today, to be clear. I never go into my recordings or into my life thinking that I'm going to talk about the clown face egg depository, but apparently I live this sort of life where people will just bring this up. I don't know why I'm so mad about this. We're going to the mid-roll. Bye. Hi, welcome to the mid-roll. We are still nameless, but by God, are we not contentless. Speaking of content, if you like ours, then can I interest you in checking out our Patreon? Cadget has Where If You Have Coin, where we've got a monthly book club podcast and also like other fun stuff like that. Real talk. I'm mostly telling you about this because the next book I think we're going to do is Going Infinite, which is about the downfall of FTX. And listen, I just really want to tell you about like the bizarre little rationalist cult that Sam Bankman-Fried created. And speaking of strange cultures, you should also check out Exolore. hosted by Dr. Moya McTire, which is all about building fictional worlds with a panel of expert guests from the biology to the culture. Personally, I'm biased, and I think you should listen to the episode Platoon Review with Amanda Silberling. For obvious reasons, if you like this podcast, you will definitely like that episode. But there's also nearly 100 other episodes and worlds to dive into. That's all from me. Back to the episode. Maybe we should explain what the clown face egg depository is, because, okay, second half of this recording was supposed to be we talk about various copyright, trademark, patent, IP issues generally. I think this is a fun one to start with because it's such a fucking edge case scenario, but Sam, what is the clown face egg depository?
I'm so delighted I get to talk about this because I actually was talking about this recently with a friend of mine who is a clown, because a lot of my friends are carnies, actually. And all the clowns know about the clown face egg depository, which is very funny because it's like such a specific area of copyright law. Anyway, so
I need to ask the person who cuts my hair about this because I think she does some carnival stuff.
yeah.
How do you guys know so many people who might be clowns?
Because I get my hair cut at the punk rock hair salon.
I spend a lot of time going to burlesque shows, and the overlap between children's entertainers and people who do burlesque is actually almost a circle.
That makes a lot of sense.
Yeah. So clowns have like makeup that is very much quite literally their trademark, right? Like clowns develop their own style of makeup that is like the same pattern that they put on their face every time they go do clowning things. And many clowns had an issue where other clowns were stealing their makeup. I don't think necessarily to like imitate them, which is what you would think of as like trademark law. Like trademarks are to protect things that like identify you as the source of goods or services. Those people were more imitating their makeup just because it was like cool and good, and like these other lesser clowns did not want to be bothered to come up with their own
The lesser clowns.
These lesser clowns did not want to be bothered to come up with their own style of makeup, and so they were just imitating each other. And all of the clowns got very upset about this. I do not know exactly how they made this decision, but all of the very famous clowns decided that they would paint their clown makeup that they had like kind of developed on eggs, I guess because it is relatively a face-shaped smooth object that's easily attainable and cheap, and then put it in like a catalog of egg faces. And then all of those eggs would be copyrighted, like sent to the copyright office, and then they could sue people for using their clown makeup. I don't know of any cases where they've actually done that. But because copyright law only protects art that is fixed in a medium, they couldn't just like take a picture of their makeup and then send it in, because the makeup itself was what they wanted to try and copyright. So they had to like fix it on a static piece of something, right? And they chose eggs. They chose eggs. And now their makeup designs are protected so that if someone else imitates their clown makeup, they can sue them for copyright infringement.
I love the concept of a bunch of famous clowns sitting very seriously in like a conference room talking about like, so what are we gonna do about this? And one of them just like raises his hand and is like, egg.
I thought you were gonna say, like, imagine them all sitting together painting the eggs, and I was like, wow, it's like
that's also really good.
It's like when you go to PAX Unplugged and you see a bunch of like very serious nerds painting their minis.
I'm now imagining an Oxford clown shoe.
Oh my god. Imagine the guy carrying all of these eggs to the copyright office too. And it's like they get stopped with this egg carton and it's like, show us what you have in there, because they're like acting weird about it, and like, you open it and it's just full of like clown makeup eggs.
I have two things. One, pitch for the title of the episode, can you copyright an egg? Two, why not like balloons? Like I feel like eggs are
more static. Balloons deflate.
Oh.
It has to be static. Like there's so many copyright cases. I think we spent a good 2 weeks in Intro to IP on how static a piece of media needs to be in order to be copyrightable. There was a whole sandcastle case.
I'm gonna keep making like I don't know why I'm making a lot of jokes about being Jewish today, but
just today.
As a Jew, I would never think to paint an egg.
As a Jew who is raised half Catholic, I did in fact paint many eggs.
Nice. I painted some eggs at a friend's house like once.
What would you rate the experience of painting eggs?
Oh, it was fun.
So you're pro painting eggs. Got it. Okay.
Yeah. I'm pro painting eggs. I am anti Christmas trees, but pro decorating Christmas trees.
I agree with that statement.
I just think Christmas trees seem like a lot of work.
They are.
Yeah, that's accurate.
One more clown face egg depository note. One of the fun/horrible things about working with the Copyright Office is that you have to send them a deposit copy, right? Like you have to send them like a copy of the painting or the movie or whatever, right? And there's a giant warehouse. You don't get the deposit copy back. They keep it. Theoretically, if they need to give it back to you if you're suing someone. In reality, they often can't find it in the giant warehouse. So somewhere in a warehouse outside of Washington, D.C., is a diorama of eggs with clown faces on them.
Can we go? Are people allowed to go to the warehouse?
No, you have to have a reason.
Clown egg hunt. Clown egg hunt.
If you ever go, I'm gonna pretend to be the client and be like, I need to go see my aunt.
I'll hire you as a paralegal for one day so you can come to the warehouse. Because basically what happens is you ask them for a deposit copy. Normally they say, no, we can't find it. And then they say, you can pay us extra money to go find it more. And then that doesn't work. And then they're like, well, we give up. You can come look in our giant warehouse yourself if you want. And so sometimes you just have to go to the giant warehouse.
Have you been?
I haven't, no, because I've never had to sue anyone for copyright infringement.
I'm picturing like the world's like weirdest like Nick Cage like movie, like National Treasure, like 3, where it's like we have to go to the copyright office to find these clown eggs.
If you ever go, you have to come back on the podcast and tell us about it.
I will, absolutely.
If you ever go, can you go look for the clown eggs?
Yes.
For like maybe like 20 minutes. Can I pay you for 20 minutes of your time?
I don't know if you can afford me, but yes.
I can afford you. For 20 minutes, probably not more.
This is like when Isabel and I were looking at a contract for something podcast related, and she was like, by the way, if I was doing this paid, it would be like $400.
Oh, it was more than $400. It would have been $800.
Oh, fuck.
No, my billable rate is over $1,000 at this point.
Fuck yeah.
No, it's okay. This will be expensable. I can expense it for 20 minutes of your time to go looking for clown eggs in the copyright warehouse.
I think you should look for clown eggs for Wow of True pro bono.
Yeah, you guys actually probably qualify. I don't think you make enough.
Woo.
We're a very net zero situation.
Yeah, no, exactly.
Everyone go subscribe to our Patreon so we can afford the clown egg search. All right, let's talk about what the second half of what I wanted to talk about today, which is that I asked all of our listeners, continuing my pitch for the Patreon, if you support us on Patreon, you get access to Discord. If you have access to Discord, sometimes I will ask things like, hey guys, what are your IP questions? Because we're going to have Guy Who Knows About IP on the podcast. And people will be like, here are our questions. So I have compiled these all in a document for us, and we're kind of just going to do a lightning round. We're going to talk about just what is going on here and what people want to know about. And also, none of this is legal advice. I cannot stress enough.
But if I say it, maybe it is, but also I'm not a lawyer.
On that note, let's start with Amanda, who put a question in her own podcast Discord server, because I support you.
I don't know.
Also,
I had a question. But so I've been thinking about formats of YouTube videos, i.e. the Hot Ones format of interviewing celebrities while they eat increasingly spicy wings. And I'm wondering if you can copyright a format. And the reason I'm thinking about this is because when I was at VidCon, a very central discussion was about can YouTubers retire and sell their channels? And if so, then channels with specific formats, i.e. Hot Ones, would be easier to sell than a very person-centric situation. So that's why I'm thinking about this. Can you copyright Hot Ones?
Remember when I was like, can I edit stupid questions?
Was this the stupid question you wanted to edit?
No, I'm just being a bitch. I'm so sorry, Amanda.
Sorry I didn't go to law school.
No, literally, I am not actually repeating Baker v. Selden. If you want to, Isabel, you are welcome to.
I'm not going to. I'm just going to point at Baker v. Selden and be like, yo, that's one of the early ones. We decided that one really quickly.
So, literally, that's, the first day of intellectual property law. They're like, can you copyright things that aren't art? Or, can you protect things that aren't, art or a trademark or, a science thing? And the answer is no, actually, you can't. And it's actually one of the mistakes that I see creatives make most commonly. A lot of my friends who are creatives, I am unfortunately a theater kid, and that is why I am such a bitch. It's the testosterone. Literally 2 weeks in, I started mansplaining. Anyway. No, you can't copyright a format is the answer to that question.
I think that it's a good thing that I asked the question. That's day one of copyright class, because I'm setting the stage, and clearly a lot of creatives don't know that, as you said. So I'm doing the world a service.
You are, yes. And I actually do wish I could regularly shake my friends who are someone infringed my blah 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 blah, and I'm like, no, shut the fuck up. No, I'm sorry.
Yeah.
I hope you say it exactly that way.
I often do, but I actually like am thinking of specific people that I won't go into detail about, but like a lot of times creatives will create a thing, like a concept, and then come to me and be like, hey, someone else stole my idea. Can I sue them? And I don't answer them because I'm not allowed to give legal advice to people who aren't my client. But if I were to answer them, I would say, actually, no, because you can't copyright an idea because that's not what the United States intellectual property regime allows for. Some other countries do allow you to have a limited amount of protection over not ideas necessarily, but there's something called like moral rights where you have a certain amount of control over like your art after you sold it that kind of gives you like veto power if you think someone's doing like immoral or fucked up with it. But the United States doesn't care about that. They only care about money.
Well, here's another stupid question that we cannot answer if it's really that stupid, but what's the difference between an idea and intellectual property? Like, is Wow If True, the podcast, our intellectual property, even though we've done nothing with legal stuff?
So. Basically, ideas have no protection. Expressions of those ideas have protection. Does this help?
Yes, that does help.
The concept of me and you talking is nothing. This is nothing, Amanda. Our fixed voices on tape is something.
Yes. And fun fact, anything that is copyrightable is copywritten as soon as you fix it in a medium. You don't have to register it in order to have it copywritten. You have to register it in order to sue someone in federal court. But there's a copyright on every podcast episode that you guys have released, even though you haven't filed for it.
Thank you, Libsyn.
I think my favorite one is where people like try to claim that like they didn't come up with something because it came to them from a ghost or perhaps in a dream or from God, which we spent like a solid like half a class on. Was like people claiming that they who made the thing were not the author of the thing because God made it. And then so you end up with like cases where the judge is like, buddy.
Can you copyright infringe God?
God can't have copyright.
What was the outcome? Can you remember the outcome of that? So literally there was a case where a woman claimed that she wrote a book because a ghost, she was like spirit medium and a ghost possessed her.
Like, didn't she get it from like a Ouija board or something?
Yeah.
Like she got like the... Like,
and so
yeah.
She was like, can I have a copyright on this? Because I like literally did the physical writing. And the judge was like, actually, no, because it's not your words. But I think he just probably didn't like her, which is fair.
But it was God's words?
No, it was
or
a
the
ghost.
ghost's
There was
words?
a
Like a
separate
ghost
one
words.
about God. I don't remember as well.
Yeah, these were very much like the edge case scenarios of like, yeah, people sure do come up with concepts.
I want to go to law school, but only one class, and the one class is just like, here's a bunch of weird legal cases involving, like, ghosts, and judges having to be like, listen, kid.
So the fun thing about law school is that, in fact, all of the cases are weird pretty much. That's how they got to be the cases that we have to read, except for constitutional law. Those tend to be boring.
I think if I ever went to go teach at law school, if I ever went back, I would try and do like a ghost law class, which is just like all of like the cases that involved ghosts.
Ghost law.
I feel like a lot of the questions that we got were all like fair use related. I feel like the one that's the most encompassing is when #Sweat asked, it's all fair use, right? Right?
My response to Sweat is, no, you're wrong. Stop that.
It's not all fair use.
This has come up on the podcast before where people think that fair use is just kind of like, nice, we're good, it's fine, it's fair use. And the thing that people don't understand is that fair use is, that comes into play after you have been sued.
You could also use it to respond to a cease and desist.
You could also use it to respond to cease and desist. Yeah, but like that's also kind of like, it's one of those things where you can't be sure of it. It's really just a defense that you're raising rather than like an affirmative, like, hey, we're good, we're covered under this. And there's like a bunch of factors. And then like, if you get to litigation, the judge is going to be like, the factors, ? Do I like them? Are you good? This is not how it would go.
Yeah, I mean, and like, I think there is another common misconception amongst creatives is that if you're doing it for free, then it's always fair use, which is simply untrue. Mm-hmm. That is one element of one of the four factors, or maybe two, depending on, like details. We'll run through the factors really quick.
Okay, fair use factors. I feel like this is actually useful information for people if you're ever like making shit that you think is under fair use. Factor 1, purpose and character of the use, which is like, hey, is this educational? Is this for a nonprofit? Is this for commercial use?
Is it
like,
for criticism?
Is this for like school?
And this is where transformative comes in. So specifically, if use of a copyrighted work is transformative, meaning that it transformed the work enough that it's like kind of its own separate piece of creative media, then that kind of makes this first factor more important than all of the other factors. It doesn't mean that automatically all transformative use is fair use, but it is much more likely to be considered fair use if it is considered transformative use.
I just like that judges were like, we're just going to create the secret fifth factor and put it underneath factor one.
Yeah, exactly. Because they don't want to think about more than 4 factors.
I get that. I also don't want to think about more than 4
If
factors.
you don't like 2-factor authentication, wait till you find out about 4-factor.
Oh no.
Hey, that was terrible. 10 out of 10.
And the question of whether something is transformative is like really, really complicated, basically. But like, it can't just be that you're putting it into a different media. That's like very explicitly a case where they said it's not transformative if you're just putting it into a different media. Like, it has to like quite literally be an entirely different piece of work.
Mm-hmm. You want to do the rest, or should I do the rest?
The nature of the copyrighted work is factor 2. So basically, this is just what is the copyrighted work like? Has it been published, or has it been unpublished? Is it commercially available for the educational market? Is it creative rather than nonfiction? And so basically, this is like not always super relevant, but when it is, it's like often very relevant. There's one particular case where someone republished like 500 words of like an entire book, but because that was one of the big juicy pieces of the book, it was a nonfiction book related to, I think it was the Watergate issue or something like that. Yeah, where it was like a interview that had never been published before, then that was still considered not fair use because it was like the heart of the work and it was also an unpublished book, and so like they kind of cut off this person's ability to like profit off of the work, which is also partially factor 4. It kind of, these things can often get mixed up. Factor 3 is how much.
I feel like that one's the most self-explanatory one. It's like, yeah, dude, how much of it did you steal? Like all of it, or
and so like in the Her example, like her voice is only like part of the entire movie, right? Like it's been a really long time since I watched that movie, but like,
wait, but could you argue like here that even though it's a small part of the movie, like it's just like one person's voice in it, that one's crucial. Without that, you don't have the movie. So in that sense, it's like,
yeah, it's the nature. It's factor 2. Yeah,
you loop back to factor 2. But then factor 4, sorry, I'm just taking over, is that like basically the effect of the use on like the potential market. So like if you're doing something commercial and it's very similar to the pre-existing commercial thing, less good. This would be like if the ChatGPT voice Sky was meant to be a voiceover for movies or something to replace the one in Her.
In that case where it was like the book where they only republished like 500 words, this was a pretty significant factor because it took away the market for people to purchase the book, because what people wanted to purchase the book for was like the juicy secrets in it, and since that secret had been revealed, they had lost a lot of anticipated profit.
Right. And then, like, I feel like this goes into a question that, like, David, I swear we will do questions asked by not people who are Amanda or David or other people associated with the podcast.
Like Sweat.
Where David was like, my question isn't funny. He's just genuinely curious. Is making GIFs fair use? Like, if Tumblr user number 3007 made a GIF of a scene, is that their own original transformative work? What if they stitch 2 scenes together? Does this juxtaposition imply a commentary? The act of making a GIF implies choosing a frame rate, images of the original that may not equal the original. Is that transformative? And I feel like we've answered this here by it would probably be considered fair use. Realistically, this is never going to be relevant because nobody is going to litigate over a GIF.
No, generally.
But also, what about when people made GIFs of the entire Morbius movie?
Hey, wait, that's a good question. Is the GIF of the entire Morbius movie fair use?
As someone who's not a lawyer, I would argue that it is different enough because you can't, like, actually watch Morbius. Like, it's
You can't actually watch Morbius. This is true about the original movie as well, actually.
Wait, so explain this to me, because I remember memes about this, but I don't remember, like, actually what happened. Was it a GIF, but it was, like, a 30-second GIF of the entire movie? Like, was it super sped up, or?
Yeah.
Okay.
Mm-hmm. It was like a super sped up Morbius entire movie.
Yeah,
because it was so compressed that, like, you're not actually, like, getting anything from it. It's conceptual art.
Yeah. Oh, I actually remember they did this with Lord of the Rings, and then I also remember that they did this with the Bee Movie, where every time they say the word B, it speeds up. So only like the first 5 minutes of it is even remotely functional to watch. And it's still up on YouTube in part because I think it's probably a pretty good fair use argument. Because like you can't functionally watch the B movie. You're not affecting the market for the B movie by putting up this joke thing about the B movie on YouTube, even if it's the entire thing.
Yeah.
It's also clearly parody. And like, oh, I feel like the other thing people get wrong is people think parody is a separate thing. Parody is not. Parody is just like folded into the four fair use factors as part of like the purpose of it.
Yes.
But like, come on, B movie.
Yeah.
Sped up. No.
I feel like if anything, that makes more of a market for the B movie.
I agree with that. I think, however, it is not transformative because they are making a GIF of their own GIF. It's not transformative because it's in a different format, and it's not transformative if you put two scenes together. I think really when you're making a GIF, for the most part, it is specifically going to the factor about how much of the work that you're reproducing. Even if it's only a 20-minute episode, you're probably reproducing at most 30 seconds of that entire episode. And so it would be pretty difficult to claim that, like, you're ruining the market or that you're, like, really substantially reproducing it. So I think that that would be the best fair use argument, personally. Again, not legal advice, rather than it being transformative or parody.
Mm-hmm. I thought another interesting question here, which is unrelated to fair use, is Baskets asked, have folks successfully killed off a meme specifically for copyright and IP reasons? I know artists and similar folks can get annoyed with the memification of their work since it usually comes with zero credit, but it always seems like there's very little you can do about it. My read was that I had never seen it successfully done, but I remembered, and then I went and looked this up, was that like after like Pepe started getting used by the alt-right, the original creator of Pepe, what's his face, Fury, whose name I'm forgetting. I think Matt. Mm-hmm. Great, love it. We love it when people know things. Matt Fury was like, "Hey, I'm suing you guys. You stop this shit." Multiple times, and he was successfully getting people to stop using like individual instances of Pepe in their like weird alt-right projects.
I do recall that. That was like one scenario in which I was like, actually, suing people for copyright infringement is a good idea, because often it seems more like these very protective giant studios that are just doing it because they have the budget rather than really considering like if it's harming them and preventing people from being creative in their own right. And that is not something that I necessarily support. Obviously, like, I get paid to do some of that work, but it doesn't mean that I necessarily like enjoy it, even if they're legally entitled to do so. I thought that this was a really good example of how you can use copyright positively. I don't know how successful he was, because I definitely still see Pepe in a lot of alt-right memes, but he did succeed in stopping the book specifically, so that's good.
But like, yeah, I feel like this goes back to like the idea versus expression thing, where he can basically stamp out individual expressions of people using Pepe, but he can't be like, I guess it's not the same thing, but it's like the concept of fraud.
Yeah, I mean, he has copyright over the character. You can copyright a character, so he has copyright over the character, so he can stop other people from using the character in anything. But one of the tasks of any intellectual property lawyer is playing whack-a-mole with the internet.
I feel like playing whack-a-mole with the internet is what we're doing every day here on Wow If True.
The name of my ska / like nerd rap band. Do you think some enterprising lobby / lawyers such as the EFF, the Electronic Frontier Foundation, could leverage the partisan courts and popular right-wing stance that I think they mean right-wingers, are being censored to defang the DMCA? I think that's an interesting thought. Honestly, I think the left has been on the back foot for so long, it would kind of be hard to get that movement together. The EFF, I mean, if anyone could do it, it would be the EFF. They're pretty cool. I think the DMCA is here to stay, unfortunately. Like, it's been established for long enough that people have stopped fighting it and care more about, like, Sesta Fosta, for instance, or just, like, the general desexualization to the point of harming, like, sex workers and queer creators of, like, the entire internet. But I think it's a good thought. I wish someone would do it. I'm not sure if the EFF and the ACLU could, like, do it together. That would be fun. You would have more of an opportunity to do so now because there is this, like, universal sort of on both sides sentiment that they are being censored by, like, social media. It would implicate Section 230, is that what it is? Yeah, Section 230, which is where they limit liability for forums, like online forums such as Facebook. for like the posts of the individuals who were posting on social media. That happened in like the early 2000s-ish, I think, and a lot of people have an issue with that because it stops Facebook, not Facebook specifically, any social media website. It prevents them from having to care so much about individuals who are getting harassed on their platforms, for example, because they're limited in the liability that people can bring against them.
Mm-hmm.
Yeah, there have been situations where like people will live stream like mass shootings on social media websites, and then those websites aren't held accountable in any way because it falls under Section 230 law.
Yeah.
I also was wondering about, like, is there a way to establish ownership over a meme? Like, in a situation like Pepe, we know it comes from a Matt Fury comic, but then what about, like, memes that are kind of lost to time where we don't really know who created them anymore? Like, the Victorious Baby meme where the baby's like, yes! I was thinking about this because a while ago I wrote about this company called Meme Depot that was trying to like revolutionize, disrupt the meme market.
Who were the people trying to who were these guys? Why did they think this was a good business idea? What the fuck?
Because they exited from other companies and had money, and they were like, it's time to capitalize on memes. But one of their ideas was in the Meme Depot, like, it's a website where you go on and you could search, like, SpongeBob memes, and then you see a whole page of SpongeBob memes, but specific users can own that depot, and then through various crypto things, you can buy, like, a token to the depot, and then as the depot grows, you get money for it. But basically you're profiting off of being the person to be like, look, I made a depot of SpongeBob memes. And that's kind of how I got started thinking about, like, what if we did an episode about, like, can you copyright a meme? But I think that maybe falls under the case of, is anyone really going to sue Meme Depot? Is Nickelodeon going to come out and sue Meme Depot?
Maybe. I mean, I know that there are some IP owners that do sue people who are, like, making t-shirts on Redbubble of characters and stuff like that. I think the difference is you don't really get paid for memes unless you're like really cool. Basically, the way that copyright works, like claiming copyright on anything works, is you just like file it with the Copyright Office and then you say that it's yours and you like sign a little declaration that it's yours.
And then it goes in the warehouse.
And they don't really look into it unless there's a reason to. And so like you are not legally allowed to, but there's nothing like physically stopping anyone from claiming copyright on a piece of art that isn't theirs. And the only time, I'm not saying do this, I'm saying hypothetically.
This is not legal advice, again.
The only time that that would be challenged is if someone who was entitled to challenge it, who had a reason to challenge it and the money to challenge it, sued that person or, you know, something along those lines. And so you can ask all you want whether or not you're the owner of a meme. The only person who knows who the owner of the meme is, or like who created it, is the person who created it. And most of those people aren't very interested. This actually happened, I think, a couple of years ago, where the original owner of the Nyan Cat meme was no longer in possession of the YouTube account, and then whoever had since become the person who had access to the YouTube account deleted the Nyan Cat meme. And this was associated with them trying to like commercialize it in some way. And then the person who created it ended up reposting it. And then the original person got it taken down. And there was a lot of back and forth, but essentially the person who owned the YouTube account is the person who got to like make decisions about whether or not the Nyan Cat video stayed up, even though allegedly they weren't the original creator of that animation.
Yeah, that makes sense because YouTube has like Content ID, which is like, if I write a song and I upload a video to YouTube with the song that I wrote, I can like Content ID it so that if somebody uploads a video with my song, then it can like get flagged by the YouTube AI or whatever.
Okay, so I feel like what we've learned here is that copyright is nothing and you should just repost all the memes on the internet. Is that correct? Is this the legal advice we're giving?
No.
Fair.
I'm happy I learned about the clown eggs.
You're welcome.
I think I had a productive afternoon recording a podcast with my buds.
I think that I really want to get inside the copyright warehouse now to find those clown eggs.
Me too. National treasure, but it's us trying to sneak into the copyright warehouse.
I think they should make a movie about that.
I would love that movie.
But would it be copyright infringement? because it was a National Treasure movie.
No, because you can't copyright a format.
For those at home, Sam is clapping now. And on that note, Sam, thanks for joining us. And thank you for listening to Wow If True. We still don't know how to end this.
Here's the ending. I love that after 4 months on testosterone, I have now become one of those dudes with a podcast.
Woo!
And scene.